Welcome, everybody. My name is Jeff Fowler, president of the Apartment Owners Association. Today, we're going to be talking about the new legislation for 2024 in California that impacts everyone who owns rental property. So before we get into that, AOA, the Apartment Owners Association, has been around for over 40 years. And there's a lot of things we do, but most people join for the forums. They join for the property management advice hotline. And yes, you can call in at any time, and we're here to help you with questions that you might have. And we hope that this video is helpful. And really the goal is to keep you in the know, because what you don't know may cost you a whole lot of money. And also, we want to make your property management experience even more enjoyable through the things that we share, the resources, the tenant screening, and all the other things, the monthly magazine. And also one of the other things that we do is we have seminars and trade shows. So coming up in January, we will have just about at all of the locations, we will be having a seminar on just how you can write off a lot of different things off for your taxes. So before you prepare those, we'll kind of show you some of those things that you can do. Those will be in person. Then February 21st, we're going to have the AOA Landlording Power Conference, which is going to be held in Santa Clara. And then in March 20th at the LA Convention Center, we're going to have the AOA $1 Million Trades Show. So there are a few different events that are going to be coming up. And anyway, if you like this content, please subscribe. If you're a AOA member and you're watching this for the first time, we do have a YouTube channel, and it's aoausa.com. We encourage you to subscribe there. And so here we're going to get into it. Our speaker today, he's been in the business for 25 years and 16 years as an attorney. He does landlord tenant litigation and evictions, so a lot more than just evictions. And he speaks at the AOA seminars, the trade shows. We have him scheduled for several of those. And he did just a tremendous job with the California Rent Control Explained video. And so just broadly speaking, what California rent control is, he did that video. You can search that up on YouTube, on our YouTube channel, and you'll find it there. And he really is a favorite at the AOA $1 Million Trade Show. He's a landlord himself, and he's also the founder and president of Brennan Law Firm. And so we're going to bring on Mike Brennan here. And it's so good to have you with us, my friend.
Good morning, Jeff. How are you?
I'm doing great. Thank you for you invest in so many different places and have helped so many landlords stay out of trouble. And we're just so thankful for you.
Well, thank you. I appreciate it. And I appreciate the opportunity to appear and do these webinars and seminars for you guys and for the members.
All right. Well, I'm going to go ahead and let you take the show over here. Okay. And yeah, so just take it away.
Okay. Before we get started, Jeff, I just want to confirm that you can see the slides.
Yes.
And it says review of 2023 legislative session.
Yes, it does.
All right, perfect. So I want to clarify that what we're going to talk about today are the bills that were presented in 2023, and many of these go into effect, well, all of them go into effect in 2024. If I bring up a date, an effective date, that's the date it'll go into effect. If I don't bring it up, in general, it means that this law will go into effect on January 1st. There are a couple of really big changes that are taking place, but they don't take place right away. And like I said, I'll bring that to everybody's attention. So we'll start right off the bat with the, let me change the screen here. There we go. Start right off the bat with, this is an overview of everything we're going to talk about today. Now, I will tell you, there was something to the effect of 2,600 bills presented last year. And a significant number of those impacted landlords. The industry as a whole had a lot of success of knocking out and modifying some really heavy bills, but still quite a few got through that will have real impacts on landlords. And this is an overview of what I think are the most important bills. I would say there's probably, I think there's 12 or 13 there, but we'll talk about security deposits, inspections, unbundled parking, eviction mandate prohibitions. We'll go through the whole list. So I'll just go ahead and get started on that. We'll start right off with AB 12. Everybody wants to know about this one. This is the security deposits law. And essentially what it does is it now, most landlords knew that they could charge a tenant up to 2 months security deposit at the beginning of the tenancy for an unfurnished apartment and 3 months for a furnished apartment. That has now changed. There's an exception to it that I'll talk about, but this new law now prohibits landlords from accepting security deposits in any amount that's in excess of 1 month's rent, regardless of whether the residential property is unfurnished or furnished. As I said, there is an exception to this that exempts owners who are natural persons or an LLC in which all of the members are natural persons. And that same owner owns up to 4 units split between 2 properties. So for example, you could have 2 duplexes, a triplex, and a single family. You could have, well, it's just the 2 buildings. So if you've got 2 buildings and they total 4 units or less, then you are exempt from this rule. Now, of course, California doesn't make anything easy. So there's an exception to that exception. So even if you are a landlord who's got 2 buildings that total 4 units or less, if your applicant is a service member, an active service member, then you are still limited to 1 month's security deposit up at the beginning. So this is going to have no impact at all on owners or management companies who already collected more than a month's rent. There's no need to return any portion of that. You can keep that, the 2 months that you've got. This law goes into effect July 1st of 2024. So for those who it will impact, people who own more than 4 units, or they have more than 3 buildings, or more than 2 buildings rather, there are some options that they can consider as, I won't call them workarounds, but I'll say that they come right out of the language in the code itself. So for example, since this goes into effect July 1st, 2024, a landlord who's going to be impacted by this could do a change in terms of tenancy. Let's say they have a tenant that's only got 1 month's rent as a security deposit. This landlord could do a change in terms of tenancy for a month-to-month tenant, and he or she could increase that security deposit to 2 months right now, provided that the property, they're not prohibited from doing so because the property is in some sort of a rent control ordinance jurisdiction or a just cause jurisdiction that prohibits that. And doing so doesn't result in an amount that's greater than 2 months security deposit. So like I said, they could change the terms of the tenancy. Let's say they lived in, let's say the property was located in, I'm just going to pick a city, Arcadia. Arcadia has no rent control of its own, no just cause ordinance. It is subject to the Tenant Protection Act, but the Tenant Protection Act does not impact what I'm stating right now. And let's say they had a tenant who was on a month-to-month tenancy. That landlord could change that, could do a 30-day change in terms of tenancy right now and increase that security deposit to 2 months. Another option that you can go with, I suspect that this one would be more difficult, but a landlord, right in the code, a landlord is still permitted to charge 6 months of advance rent. So it has to be a minimum of 6 months. So if you've got and this happens surprisingly more often than you would imagine, but I have clients all the time who call me, or at least, I don't know, every month or two, I get a client call who says, Mike, I have an applicant that wants to pay me a year in advance. Well, that's okay. You can accept that as long as it's a minimum of 6 months advanced rent. You can go ahead and take that, especially if their credit is questionable. And the point of that would be, you've got that advanced rent. You got a tenant in there that had some questionable credit or something in the screening process that maybe caused some concern. You've got that ability to charge them 6 months advance rent on top of a single month's security deposit. And then finally, and this is one that this is an idea I'm kind of unpacking. I haven't worked all the way through it yet, but another option you can do is, again, this comes right from the code. It says that a landlord can enter into an agreement with the tenant for the landlord to be paid to make various alterations, including decorative, furnishing, or structural alterations. So one thing that I can see landlords doing as time progresses is, instead of providing these very nice apartments, I can see landlords moving into a situation where all they're providing is a very basic vanilla unit with no blinds, no granite countertops, nothing but the absolute essentials to make it habitable. And if the tenants want those upgrades, the landlord can enter into a contract to pay for those. The tenant will pay for those upgrades. And that might be something that's worth exploring, because typically, if the tenant only has to pay 1 month's security deposit, that's fine. But if you tell them, if you want these upgrades, you've got to pay for them, they typically tend to take better care of the unit than when all of those upgrades are provided in advance. So, like I said, starting July 1st, 2024, we've got a new law that goes into place that limits the security deposit to 1 month's rent. There's a couple of exceptions. Well, there's really one exception. Landlords who have a total of 4 units between 2 buildings or less. And the exception to the exception is that if that same landlord is dealing with a active military individual or active service member, they're still limited. I gave at least 3 options that a landlord can look at that can possibly, like I said, it's not a get around, it's not a workaround, it comes right out of the law, but 3 options landlords can take to kind of mitigate the challenges that are posed by AB 12. Okay, so the next one we're talking about, let me change that slide, is AB 548, and this is inspections. And this one, it does cause me a little bit of concern. This law deals with inspections and requires local enforcement agencies to develop policies and procedures by January 1st, 2025. And those policies and procedures are in connection with the inspection of multifamily properties, where an inspector or a code enforcement officer has determined that a unit in the building is either substandard or in violation of state habitability standards, and those conditions have the ability to affect other units in the property. So the problem with that, as I see it, is, well, let me play out a realistic scenario how this will take place. So by January 1st, 2025, these local municipalities have to have these policies and procedures in place that is going to allow an inspector to inspect any unit they want on the property when they find one unit that's either got habitability issues or is deemed substandard. And if you're wondering what those standards are, you can look up health and safety sections 17,920.3 and 17,920.10. If you look up those sections, it'll go over everything that's involved in what would make a property substandard. It's a long list. But there's also lead contaminants. The 17,920.10 deals with lead contaminants. So let me give you the scenario I see playing out here. Probably a tenant who's either behind in rent or knows they're going to fall behind in rent because maybe they lost their job. They call the city and they say, hey, I've got some habitability issues in my unit. And the city comes over and does an inspection, and indeed they find habitability issues. If that inspector deems that these habitability issues have the possibility of impacting another unit, that inspector has the right to inspect those other units. And like I said, that just opens Pandora's box, especially in situations where maybe the landlord or the tenant hasn't notified the landlord about any of these situations at all. So, like I said, the concern is that it gives the inspectors a lot of discretion that to inspect any unit on the property, even if the tenant never complained about it. And there's no provision for existing conditions, nor is there any affirmative requirement on the part of the tenant to notify the owner of a problem. And so that's the concern. I think one of the remedies to consider is the landlords may need to develop some sort of an addendum that is signed at the inception of the lease that has an affirmative provision in the lease requiring the tenants to notify the owner in writing of any maintenance or repair issues, as well as a provision stating that the tenant's responsible for any sort of reinspection fee associated with the problem in the absence of proof that they notified the owner of the problem in writing. And that failure to pay that reinspection fee would be a material breach of the agreement. So let me try to summarize that. So far, what I'm trying to unpack is the language for a provision that states, look, you are the tenant. You have an obligation to maintain this property or notify me in writing when there's a problem. If you don't, and I get a citation, when the inspector comes out to do the reinspection, Unless you can prove that you put it in writing prior to that first inspection, then you're going to be responsible for that reinspection fee. And if you fail to pay it, it will be a material breach. Now, there's some issue that I can see popping up as to whether somebody somewhere is going to claim, well, that's an illegal rent increase. And I don't believe that to be the case right now, but we'll figure that out as time goes on. But that is AB 548. All right, moving on, we've got AB 1317, unbundled parking. This goes into effect January 1st, 2025. So there's a whole year before this one goes into effect. But this one won't really impact too many people who are going to be watching this webinar. This requires owners of multifamily apartments to unbundle from the rent for the life of the property, all of the parking at the property. So what does that mean? Basically, it means if you rent a property that typically comes with a parking space, when you go to calculate what is rent, you will not be able to calculate the parking space in the rent. And we'll get to why they're doing that in a moment. But most landlords traditionally have never charged the tenants for the parking space that came with the unit. In 2019, when the Tenant Protection Act was passed and we knew it was going into effect, I started telling the landlords, hey, take away the parking and charge for the parking separately on a separate agreement. And that's actually exactly what this law now requires. It requires landlords who have brand new units that were issued a certificate of occupancy after January 1st, 2025, where the property has 16 or more units, they have to take that parking out of the rent and put it on a separate agreement. So that may seem like a great thing. Initially, when I was reading the bill, I was like, oh, that's great. That's exactly what I've been telling people to do. The problem is, it dawned on me later, eventually those buildings become, or they fall under the Tenant Protection Act, which, as everybody knows, is a form of rent control. And what they're doing is they're taking the parking out of the rent so that the net rent amount will be lower. And so the increase on the tenant's share of the rent, or the increase to the tenant for their rent, will be lower. And so I figured it out. That's what they're trying to do. They're trying to reduce the increase in monthly rent that the tenant would be paying. Well, that in and of itself wouldn't be a terrible thing if you could just rent that space out to anybody you wanted to, but that's not the way the law is written. First of all, you have to give the first right of refusal to parking spaces to the tenants that live in the building, whether built specifically for the property or after the property was built. The tenants at the property have the right of first refusal to lease those parking spaces. The second problem is, if the tenant fails to pay the rent, you cannot do an eviction on, obviously you can't do an eviction on the tenant for their apartment, but you also can't do an eviction for the parking space for non-payment. Any tenant's failure to pay the parking fee pursuant to a separately leased parking agreement shall not form the basis of an unlawful detainer action against the tenant. Your only remedy, if the tenant isn't paying rent, is after the 45th day, the property owner can revoke the tenant's right to lease that parking spot. But from a practical standpoint, I'm not sure how you're going to do that yet. You can put parking signs up that say, hey, if you don't have a right to park in this space, I'm going to tow your car away at your expense. And every time that the tenant parks in that space after that 45th day where they're late on the rent, you can tow their car away, and probably they'll get sick of doing that. But I don't know what happens is if they pay the rent on day 46, does that mean that they're now going to be entitled to park there again? I don't think so. That, the law is not a model of clarity when they drafted it, but it is going to cause some problems. But like I said, this is for buildings that are 16 plus units and their certificate of occupancy was issued on or after January 1st, 2025. So like I said, it really won't affect too many people right now. Oh, and I'm sorry, there's also one other aspect of it that's important. It isn't for every single property that met that criteria. It's only for properties located in the counties of Alameda, Fresno, Los Angeles, Riverside, Sacramento, San Bernardino, San Joaquin, Santa Clara, Shasta, and Ventura. So it doesn't cover every county within the state. There are some exempted properties. Those are units with garages and affordable housing for low and moderate income properties. And again, these are going to be, it's only going to affect properties that are built on or after January 1st, 2025. All right, let's go on to AB 1418. This is eviction mandates by municipalities. Before I get into what the law says, let me give you the background on how this law came about. It was very common for cities to have programs in place that essentially worked like this. Let's say you had a property that was in a rough neighborhood, and that property either had a tenant or the tenant had friends that would come over and visit that were affiliated with gangs, or there was a criminal element associated with either the tenant or the tenant's acquaintances, or the tenant had had some sort of a run-in with the law. It was very common for the city to go to the owner of that property and say, hey, your tenant is either a known gang member, or they've had a run-in with the law, or they bring people over who are known gang members, and we want you to evict them, or we want you to, here's a list of tenants. I know you've got a vacant unit. Here's a list of tenants that are problematic in the neighborhood. If they apply to your property, we don't want you to rent to them. And this law changes all that. This law limits the ability of any local government to adopt any sort of local ordinance, rule, policy, or regulation that penalizes either a tenant or an applicant or a landlord because the tenant may have come in contact with any sort of law enforcement. Nor can the municipality require landlords to do it themselves. So the municipality can't do it, nor can they force the landlord to. And essentially, this law makes it illegal for the municipality to force those landlords to take negative actions towards a tenant as a result of criminal activity. And it specifically prohibits any sort of program that imposes penalties against an owner or a resident because of that interaction with the law enforcement. It imposes penalties on landlords for the failure. It imposes penalties on both landlords and municipalities if they go ahead and violate these prohibitions. So I won't spend a ton of time on this. Like I said, it is common for these cities to have these programs where they go after the landlord and force the landlord to evict somebody. And now basically this law prohibits them from having that. I will tell you that if a city or a municipality is attempting to do that and the landlord moves forward with it, this law also allows a third party to act as a party in a lawsuit. So in other words, that third party can go to court and seek an injunction against both the landlord and the municipality to stop any sort of eviction that took place as a result of these interactions with criminal components. All right, let's talk about AB 1607, LA County Affordable Housing Solutions Tax Transfer. So it's known as the LA County Affordable Solutions Act, and it creates the Los Angeles County Affordable Housing Solutions Act, which I think it's kind of humorous. If you look at that acronym, it's actually La Casa. And this program transfers a portion of tax revenue to LA County to fund various tenant protection programs. It also authorizes additional funding measures to be on the ballot in Los Angeles County to raise funds for programs down the line for purposes of what the law says is for purposes of preserving existing housing. That might mean buying it, funding renter protection programs, and financing new construction of affordable housing developments. So the agency's stated purpose is to increase the supply of affordable housing in Los Angeles County, to provide significantly enhanced funding for technical assistance at a regional level for renter protections, and to provide new affordable housing production with priority on the lowest levels of affordability. The law specifically requires that at least 30%, think about this for a second, 30% of the total annual program budget shall be spent on countywide renter protections. And these programs, the renter protection programs, include pre-eviction, eviction legal services, counseling, advice, consultation, renter education and representation, and services to improve habitability. Now, we all know what that means. It means right to counsel. 30% of the budget is going to go to these tenant protection programs and this right to counsel concept, which basically says any tenant in any courthouse throughout LA County that has had an eviction filed against them will now receive free legal assistance by a paid attorney. And I can tell you that just in the last 8 months, 6 months maybe, we've seen an explosion in tenants' rights attorneys. We don't have just the big five that we used to have. We're seeing tenants' rights attorneys pop up that we've never seen before. They're firms that have been around for a long time, have never done tenants' rights lawsuits. And so we already see the impact of this type of a law. So at least 5% of the budget out of this law is going to, of the total program budget is going to be used for collecting and tracking information related to displacement and displacement risks, rents, and evictions in the region. So they're going to spend money just to track evictions. Now, like I've said many times in the past, I don't mind that they track evictions. I think it's a fantastic idea, as long as they track the outcome and make that public as well. What do I mean by that? If you want to track an eviction, because they always say this, oh, evictions are up 400%. Well, it's no surprise they're up 400% since COVID. The county spent 3 years telling landlords they couldn't evict anybody, even though they weren't paying rent. So 400% is not a huge surprise. What they don't tell you is the vast majority of these cases are settled with a waiver of all the non-payment of rent and a sealed record, so no landlords know that this person was even evicted. And oftentimes the landlords tell me, hey, Mike, just pay them money. I want them to leave and I'll waive the rent. So like I said, I don't mind them producing or making public this data that they're collecting, as long as there's a final outcome that's made public as well. So we can start tracking what I would say is over $1 billion of transfer and wealth as well. So in essence, what this law does is it authorizes the transfer of tax revenue to the county for homelessness programs such as right to counsel. Let me make sure I'm not missing anything on this one. Oh, it does provide for rental assistance. I'm glad I checked that. The rental assistance program is up and running now, and that is designed to help small landlords, and a portion of that tax revenue is flowing into that. I don't want to knock that effort. That's exactly what we've asked for, is to help landlords, is to pay these landlords. But what I can say about the program right now, anyways, it's incredibly slow. I have multiple clients who, as part of the eviction, they said, yeah, Mike, let's do it. They've been a good tenant. Let's take the what we call ERAP funds, rental assistance program. The problem is they've been waiting now months for this program to actually process the paperwork and get them their money. And hopefully that will change over time. What I'd like to see, to be candid, is more of that money being funneled into a renter's assistance program where the landlords are getting paid, rather, and take that money out of the right to counsel program, where we're not just wasting our time in court and those landlords are receiving the money. Hopefully that will take place if we can track how well that works, and if enough landlords participate in those programs. I think that would the LA City and county would be open to that, but it's not happening right now. 5% is going to that at a max, and 30% is going to the other programs, if I read it correctly. And so, it's just painfully slow. All right, having said that, let's move on to AB 1620. This is a disability relocation mandate. Now, this is also very important. This is not a state law. This is a law that impacts local municipalities who already have a rent control ordinance in place. And this law is an amendment to the Costa-Hawkins Rental Housing Act in connection with disabled tenants who want to transfer to a comparable or smaller unit to accommodate their disabilities. So what exactly does that mean? This law authorizes a jurisdiction to require owners of units that are already subject to a rent control ordinance to permit a tenant who is not being evicted for non-payment of rent and who has a permanent physical mobility disability to move to an available, comparable, or smaller unit that's located on an accessible floor and retain their current lease and their rental amount, provided several conditions are met. So those conditions include: the move must be necessary to accommodate the tenant's disability. The new unit has to be in the same building or on the same parcel with at least 4 other units. There's no operational elevator that serves the floor of the tenant's current living unit. The tenant provides the owner a written request to move into an available unit that's located on an accessible floor before that unit became available. In other words, they can't wait until a unit becomes available and say, oh, hey, here's my written request. They have to have actually given that written request before there was a vacant unit. The new unit does not require renovation to comply with an applicable health and safety code. And the rent control board determines that the owner will continue to receive a fair rate of return or offers some sort of an administrative procedure ensuring a fair rate of return. So what does that mean? What that means is that a tenant cannot go, let's say you had a tenant that lived in the property for 20 years and their unit has become incredibly run down and they have submitted their written request, prior to a vacancy. And you've got a unit that maybe you renovated a year ago and has been upgraded and is in great shape. And sometime after you renovated it, but before it went vacant again, the tenant submitted their written request to move into a lower floor unit, and that unit for some reason became vacant. That tenant should not get that windfall of moving into a newly renovated unit at their same rent when they've lived in their unit and run it down over the last 20 years. And so this law requires that the city who implements this will have some procedure that would allow that landlord to be able to maintain a fair rate of return based on that tenant's move. In other words, it wouldn't be fair to lock that landlord in to that old rent for a 20-year-old tenancy, but in a new unit. And the state legislators are trying to provide some sort of a mechanism that allows that landlord to seek a higher rent. Again, this law will not apply where less than all of the tenants on the lease agree to move to the available unit. Let's say you had 4 tenants in the lease, and only one of them wants to move and the others don't. The owner does not need to let that tenant move. And it does not apply where the owner or their spouse or their family member also wants to move into that vacant unit. There are some additional components to this. For example, the security deposit in the old unit will have to be dealt with in connection with the old unit, and which would seem to imply, it doesn't really say this, but it would seem to imply that the landlord would be allowed to go after a security deposit in connection with the new unit. That may or may not make sense in light of the new security deposit law. You'd have to see how that played out. And like I said, there's some additional components to this law that I'm not going to go into right here. But I would encourage any owner of a property that's located in any sort of a rent control jurisdiction to become familiar with this AB 1620, because the tenants, you are going to start receiving these, what I would call a reasonable accommodation request to allow that tenant to vacate, and you will have to look into it. You will have, in most instances, you'll have to allow it. Okay, that takes us on to AB 1679, another tax, of course. This is the LA County transaction and use tax increase. And this new law allows Los Angeles County to impose higher transaction and use taxes that exceed the current 2% statutory limitation. As of now, LA County's existing transaction and use tax, which is known as Measure H, it's not the same Measure H as Pasadena, but it's capped, it's at 0.25%. And this law is going to require that Measure H be repealed, and then it's going to allow that to be doubled to 5%. And as a result, it'll take that whole tax up to an amount that's higher than 2% when that 0.5% is added into the other taxes. So it specifically dedicates the additional tax revenue to addressing and preventing homelessness. And of course, again, by now we all know what that means. Among other things, it's paying for private attorneys to prevent you from evicting your problematic tenants. We're not going to spend too much time on that. SB 48 is the California Energy Commission state goals for clean energy. Now, the reason I included this in here is because over the next several years, we're going to be seeing a lot of clean energy laws passed. And I'll talk about the impact of those in a second. But for right now, this law is known as the Building Energy Savings Act, and it requires the California Energy Commission and other agencies to develop a state strategy to achieve state goals for energy and greenhouse gases and emissions from existing buildings. Keep that in mind. I encourage everyone to follow the trajectory of this law. I want owners to understand that a lot of this clean energy law, or a lot of the clean energy laws that are going to be coming into existence and fall under this umbrella, are going to have disastrous economic effects on landlords. For example, the requirement right now, there's a requirement that the state is trying to get rid of all gas appliances and force landlords to go all electric, which is just going to result in exorbitant costs to landlords, many of whom are not going to be able to recoup those costs. They may not even be able to afford the upgrades. And as a result, they're going to be forced to sell their property to a larger corporation that can absorb those costs. And of course, this law, every year Sacramento says, hey, we don't want these properties going to these big corporations who own, thousands and thousands of units. But every law they pass does nothing but push these properties, the mom and pops, out of the business and push the properties right into the hands of the corporations. They say they don't want to own these properties. I read actually a report recently that was titled that the impact of California's clean energy laws are unwittingly going to lead to what are known as renovictions. And the point of the article was that, you've got this Tenant Protection Act that says, hey, you can't evict tenants for just any old reason anymore. They have to be doing something wrong, or you have these no fault reasons, such as substantial remodel. And these renovations that are being forced on landlords amount to a substantial remodel. And what it's going to do is it's going to displace entire buildings. And then that's going to drive the rents up to a market rate again. And so it's going to have the exact opposite effect of the legislation that Sacramento says they want in place to protect tenants. In other words, it's not going to protect these tenants at all. So like I said, for landlords who haven't really understood the impact of these clean energy laws yet, keep that in the back of your mind when you're seeing these laws come out and they say, oh, it's for climate change, it's for sustainability, it's for this, it's for that. Think about the impact that's going to have on your buildings and tenants in general. All right, moving on, we've got SB 71, which is increased small claims limits. I think this is actually a good law. Specifically, in actions brought by a natural person, they can ask for up to $12,500, but it also increases the amount you can ask for in what are known as special proceedings. Now, for those who don't understand this yet, unlawful detainers are special proceedings. And in those cases, as long as you could have brought it as a special proceeding in a limited civil case, which unlawful detainers, the vast majority of them are, you can now seek up to $35,000 in small claims court. So what that law refers to, again, we're talking about the unpaid COVID rent. So let me just remind everybody, Los Angeles COVID repayment schedules are all of the unpaid rent that accrued during COVID between March 1st, 2020 and September 30th, 2021. All of that became due August 1st, 2023. And for any unpaid COVID rent that became due between October 1st, 2021 and January 31st, 2023, that's all going to become due February 1st, 2024. Now, what you can do is, for all of that rent, that's, what are we, 6 weeks away from that? You have an option now. You could serve a 3-day pay or quit for all of that unpaid rent immediately and file an eviction. And for some of you, I suspect you will. But it also means you could, let's say your tenants were prior to COVID, they were on track, and they're on track again, and they've generally been a good tenant. Instead of filing an eviction, you could also take that amount right as of February 1st and go right to small claims court and file a small claims action against the tenant as well. And I've had clients who have done it, and they've already gotten their judgments. I will say that there's a challenge to that. Last year, in 2022, many of you remember Gavin Newsom signed a law that changed the judgment enforcement metrics. And basically, the only way to collect from most tenants in the past was to use a wage garnishment. And Gavin Newsom signed a law that actually changed the metrics for that and pushed the minimum amount, the hourly wage, up to what amount in the city of Los Angeles, it amounts to more or less $40 an hour. In other words, the tenant has to be making $40 an hour for you to be able to use a wage garnishment to collect a judgment. Well, most tenants aren't making $40 an hour. And if they were, you probably wouldn't be evicting them anyway. So like I said, there is, you do have that ability to go to small claims. If you got your judgment, you could go after it. I don't know if you'll be able to collect using a wage garnishment, but certainly one thing you could do is if you filed it in small claims, you could use that as leverage either to ask the tenant to vacate and sign an agreement that says you're going to dismiss that case and you're going to never go after that money again. Or you could tell the tenant, hey, I intend to file this action as an eviction, but I'm willing to waive that as long as we enter into an agreement that says you're going to vacate. So basically, the increase in the amount in controversy that you can seek in small claims court has now given you a little bit of extra leverage against a tenant that has failed to pay you rent. Okay. Moving on to SB 267, the credit report screening limitations on government subsidized apartments. So this law amends existing government code that already prohibited discrimination in the application process. More importantly, though, it only applies to applicants of government subsidized units. So in other words, units that are receiving Section 8 or landlords who receive the VASH voucher program. And the way it works is under the current government code, Section 12955, California Fair Employment and Housing Act prohibited the use of financial or income standards on that portion of the rent that was paid solely by the tenant. So in other words, if you had if your rule was 3 times the rent in gross income, you would only apply that to the tenant's portion. You couldn't apply that to the portion that you received from Section 8. Well, that law remains the same, but now this new law adds to that by prohibiting a landlord from using an applicant's credit history as part of the application or the screening process without offering that applicant the ability to provide verifiable alternative evidence of their ability to pay their portion of the rent. So the housing provider has to give the applicant reasonable time, they don't really define that, but reasonable time to provide that alternative evidence and reasonably consider that alternative evidence in lieu of a credit report. So what constitutes reasonable evidence that can be used? Well, they've got a list of 3 things, and it says it includes but not limited to government benefit payments. So we're talking Social Security or something along those lines. If they have electronic debit cards where they can get food, that would count. Pay records, bank statements. So those are the 3: government benefits, pay records, and bank statements. Those are the 3 they list. But like I said, it does say including but not limited to. So to be safe, I would look at anything that could be verified. If it can be verified that it's legitimate, I would consider it. But what does the law not do? It does not limit the ability of the owner to request documentation, to verify employment, to request landlord references, or to verify the identity of an applicant. So you still have that screening process. You still get to go through the entire screening process. But for tenants who are receiving government subsidies, you cannot rely solely on their credit report. You have to allow them to produce additional evidence that says, hey, I am a good risk. I do have the ability to pay. So what I would suggest landlords do is start thinking about that now. If your building receives any sort of government subsidy, I would start thinking about, okay, what would I list as acceptable forms, and how am I going to go about verifying those forms? And I would get that in place right now before this law actually goes into effect, which is January 1st. And then I might even include that information in my application just so the tenants know. Okay, moving on now. We've got SB 712. So I'm skipping one in my notes, and I'm going right down to SB 712, and I'll come back to the other one, which I believe is the last one. But 712 is owning, storing, and charging micro mobility devices. So what does this new law do? Well, it prohibits landlords from preventing tenants from owning or storing and recharging one personal micro mobility device for each occupant. And when I say preventing them from owning it or storing it, I mean storing it inside the unit. There's an exception we'll talk about in a second, but it's kind of an unrealistic exception. But in other words, for every single occupant you have in your unit, they get to own a micro mobility device, and they get to store that micro mobility device in your unit, and they get to charge that micro mobility device in your unit. So what do I mean by micro mobility device? Well, typically what you would think of is some sort of an e-bike, an electronic bike, or an electronic scooter, but the code also defines it as any other small, lightweight, wheeled electric powered device that's used for transportation. Okay, now let's talk about the provisions and requirements and prohibitions of the law. So owners and operators are prohibited from prohibiting the storage of the device in the unit, provided the vehicle meets one of the following codes. And I won't bore you with codes, but what I will tell you is it has to comply with the UL 2849, which is, if you don't know what an UL is, it's Underwriters Laboratory. And so that would be for e-bikes. For e-scooters, it's UL 2272. So I'm going to repeat that. For e-bikes, it's UL 2849. For e-scooters, it's UL 2272. So why am I giving you those code sections? Do I want to just bore you to death? No. I want you to read them, and I want you to build that into your lease. That they are required to comply with those safety standards, and that the tenant is required to prove to you that their e-bike or e-scooter complies with those. Why? If you don't already know this, there are a lot of problems with those batteries, the storage of those batteries, the charging of those batteries. Many of you already know this, a Tesla, which is a very expensive, great vehicle, expensive vehicle, but they can just erupt into flames as a result of their batteries. And anything that uses a lithium battery runs that risk as well. At least that's my understanding. I'm not an electronics guy, but I have read plenty of articles that talk about these lithium batteries and their potential to catch on fire. So much so that, as you probably know, you're not even allowed to ship these things without notifying the post office that, hey, I'm shipping these batteries, etc. So that's the problem. That's why I want you to know those codes. That's why I want you to build those codes into your leases. You are allowed also to require insurance for storing that device in the unit. And I would build that into your lease if you don't already have it. Most leases today say, we encourage you to get renter's insurance. We think it's a great idea. I would change that to, you are required to maintain renter's insurance. And that's not whether they have e-bikes, or I should say that's whether they have e-bikes or not. I would just change my leases to requiring all tenants to carry liability coverage, not just the coverage that says, hey, if your property gets lost or destroyed because of a flood, you're going to get reimbursed. I'm talking about actual liability insurance, where if they cause a problem on the property, their insurance company is going to kick in and at least help take care of it. All right, so there are some exceptions. Owners and operators, management companies may prohibit the tenant from charging a device in the unit if the device does not meet those standards. That's number one. They may also prohibit storing and charging if the owner provides secure long-term storage. Well, what does that mean? Well, it means a location with the following characteristics. It's got to have access that's limited to residents in the same housing or the same building. It's got to be located on the premises. It's got to be reasonably protected against rain. And it has to have a minimum of one standard electrical connection for each personal micromobility device that's going to be stored and recharged in those locations. And you can't charge the tenant for using that storage. Now, that one before that, the one connection for each device, that's why I say this is unrealistic. No owner, you don't even know how many occupants your building is going to have at any given time. You can guess, but you don't know with certainty. And no owner is going to provide outside storage that's got one charging station per device. So essentially, you're going to end up with these in your units. And so, like I said, I would really encourage you guys to require renter's insurance or liability insurance. Also, another exception is you're not required to modify the building. You're not required to allow the tenant to modify the building to accommodate this stuff. Really, they've got to comply with those UL charging codes. And you may want, if it's not already built in your lease, you should have it built in your lease that you conduct inspections once a year on your properties. And you have the right to go in and inspect the devices and the charging capacity or the method used to charge them to determine that they are in compliance with those codes and they're not going to burn your building down. And then finally on this law, you may prohibit the maintenance and repairs of motors and batteries on these devices. What you are not permitted to do is you're not permitted to prohibit them from changing tires, and you're not permitted to prohibit them from adjusting their brakes, but you can prohibit them from working on the motor and from changing the battery inside the unit. Okay, I think that covers all of that. Let me just see real quick. I'm sorry, one other aspect of that, and this should be built into the lease. The bill also mandates that the tenants are required to store micro-mobility devices in compliance with the lithium-ion battery safety guidelines issued by the Office of the State Fire Marshal each time they're amended. So they've got to meet that UL code, and they've got to meet that fire marshal's storage of lithium batteries document every time it comes out. Okay, so last but not least, that leads us to SB 567, changes to the Tenant Protection Act. And I know a lot of people were very interested in this one as well. And I think this is a big one. For any unit that's not already covered by some sort of a local jurisdiction, rent control, or just cause ordinance, at some point your properties will become subject, in most cases, subject to the Tenant Protection Act. And this law amends that. So it amends both the rent control and the no-fault provisions of the Tenant Protection Act of 2019, which is commonly known as AB 1482. We're going to break it apart and break those sections into two and talk about the changes to each one. So under the rent control portion of the TPA, it adds penalties and fines for violations of the increased rental limits. So what am I talking about? Well, the law, I'll get into a little bit more detail in a second, but the law is basically saying if you're a landlord and you increase the rent more than you were supposed to, then you are now subject to civil lawsuits, penalties, and fines for that action. So the way it's worded, which is a little bit concerning, it says any owner who demands, accepts, receives, or retains any payment of rent in excess of the maximum rent allowed shall be liable in a civil action by the tenant for injunctive relief, means they're going to make you stop, damages in the amount of the overage, attorney's fees and costs, and damages of up to 3 times the amount if the court believes the owner acted willfully or with oppression, fraud, or malice. Let's just stop there. That is a crazy definition. So if you accidentally demand, let's say you calculate your rent increases, and for many of you have called my office over the years and say, how much am I allowed to raise rents? And I tell you, I do not calculate rent increases. This is a perfect example of why. We don't calculate rent increases because the laws are written that, and they create such liability that we're not willing to accept that liability. So, but if you do it yourself and you accidentally, let's say your calculator rounds it up and you increase the rent by even a penny, the way the law is written, not just this law, but several laws in conjunction with this, is that is an illegal rent increase. And every legal rent increase after that is also illegal. And so you could go, and I've seen this happen, you could go 20 years without anybody knowing that there was an illegal rent increase. And when you go to evict them, the tenants' rights law firm does all the math, goes back, they figure out 20 years ago, you increased the rent by a penny more than it was supposed to be. And every rent increase after that was illegal. Well, guess what? Not only are you now on the hook for all of that money, and it can be tens of thousands of dollars, but you're also on the hook for attorney's fees and costs. And if the court said fines, and it could, even if it was an accident, if the court finds it was how was it worded, willfully or with oppression, fraud, or malice, then you're on the hook for punitive damages as well. So most of the people who hear this law sit there and go, well, I'm not going to increase their rent more than I'm allowed to. I'm not worried about it. What I would suggest to you is, I'm going to suggest to you it could happen by accident and you don't know. And so what I would say is, when it gets down to it, if you have any question, round down. Do not round up. Okay, round down. Avoid all this nonsense and avoid these potential lawsuits. Now, who can bring these actions? Well, the tenant can bring them, but they can also be brought by the attorney general or a city attorney in a local jurisdiction. And they get all the same remedies as the tenant did. So they can get an injunction, they can get the punitive damages, actual damages, plus, if the tenant had to vacate or said they vacated as a result of the rent increase, they would be entitled to damages for that vacating, moving costs. It's kind of a nightmare. So that's just the rent control provision. Now let's talk about the just cause aspect of the Tenant Protection Act and how SB 567 changed that as well. So first of all, we're going to talk about owner occupancy terminations. I'll start off by just kind of repeating the current law. It's not necessarily a change, but it's important to remember where the owner occupancy terminations are at right now. So for leases entered into on or after July 1st of 2020, you can only terminate a tenancy as an owner occupancy if the tenant agrees to it in writing, which they're not going to, or there's a provision in the lease that allows the owner to terminate for owner or family members, for owner occupancy or family members. All right, so that's the current law. This now changes the requirements of an owner-occupied termination, and the owner can now only evict for that if there are no vacancies of a similar unit on the property. I'm sorry, I changed that slide. And the intended occupant does not already occupy a unit at the property, and the owner or family member must now move in within 90 days of the tenant vacating. So that means when the tenant vacates, if you want to upgrade that unit, you've got to get it done in 89 days. They've got to take possession in 90 days. Not a huge deal. But the owner or family member must also live there as their primary residence for a minimum of 12 continuous months. Also probably going to happen, not a huge deal. If the intended occupant fails to occupy that rental unit within the 90 days after that tenant left, or fails to occupy the rental unit as their primary residence for at least 12 consecutive months, the owner has to offer that unit back to the tenant who vacated at the same rental rate and under the same lease terms that were in effect when they vacated. Plus, they have to reimburse the tenant for reasonable moving expenses incurred in excess of any relocation assistance that was paid to the tenant when they received their termination notice. All right, there's also changes. I'm still on the owner occupancy. There's also changes to the termination notice. Now, if you're going to do an owner occupancy under this law, that termination notice has to contain the name of the intended occupant and their relationship to the owner. So you can't change it last second. You can't say, let's pretend it's I'm your son. You can't say, oh, we're going to lease it to my son, Mike Brennan, and then at the last second say, oh, my son didn't want it, so my daughter wants it, or her name is Lisa Brennan. All right, you can't do that. It's got to contain the name of the intended occupant and their relationship. And the notice has to notify the tenant that they can request proof that the intended occupant is an owner or related to the owner, and they get to, proof that that proof that they request has to be provided upon the request. So in other words, they could say, I don't believe you that Mike Brennan is your son. You need to prove it. Okay, a little weird, but that's the law. So that's the owner occupancy. Let's touch real quick on substantial remodel or demolition terminations. So as you know, you can terminate a tenancy under the Tenant Protection Act to either substantially remodel or demolish the unit. Quick review, substantial remodel means either the replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a government agency. Current status of the law is you don't have to pull the permit, but whatever you're doing has to require a permit. And that includes the abatement of hazardous materials, including lead-based paint, mold, or asbestos. That may not require a permit, but if you are abating hazardous materials, that's also a reason to terminate the tenancy. All right, regardless of the work being done, the work must be to the extent that the tenant cannot reasonably live in the unit while the work is being accomplished, or at least they can't live there in a safe manner. And it's got to require the tenant to vacate the unit for at least 30 consecutive days. So those are the three elements. You're going to touch one of those systems, an electrical, plumbing, or mechanical system, and doing that work requires a permit. That's one. It's got to be to the extent that the tenant can't reasonably occupy the unit in a safe manner while the work's being done. That's two. And it's got to require the tenant be out for 30 days. That's the current law. So what's changed? Well, the new notice requirements state that the written notice terminating a tenancy under those shall include a statement informing the tenant of the owner's intent to either demolish the property or substantially remodel it. The statement has to have very specific language, which I won't bore you with right now, but it's right in the code section. It's got to have a description of the substantial remodel that you're going to complete. It's got to have the approximate expected duration of that substantial remodel. And if the property is going to be demolished, it's got to have the expected date by which you're going to demolish it. And the landlord now has to provide either copies of the permits that are required to do the substantial remodel or the demolition, or if the work is going to be done for something that doesn't require a permit, like the hazardous waste, you've got to include a copy of the signed contract with the contractor who's going to be doing the work. And then finally, you've got to have a notification that if the tenant is interested in reoccupying that rental unit following the substantial remodel, the tenant's got to inform the owner of the tenant's interest in reoccupying and provide the owner with the tenant's address, telephone number, and email address. Now, that doesn't mean that they get to reoccupy on the same rent or under the same lease terms. It just means if they're interested, once the work's done, if they want that unit, they've got to provide you with that notice with their new address, their telephone number, and an email address. All right, another change to the law is that it now provides for additional enforcement mechanisms for violations of the rent increase and the no-fault just cause provisions I just talked about. So if you fail to comply with any portion of the law, it renders your termination notice void, you'll lose your eviction. And now, like I said before, these are considered material violations, and the landlord's going to be subject to these civil actions for all of the damages I talked about. Actual damages, reasonable attorney's fees and costs. And like I said, if the court determines that you were doing something willfully or with oppression or fraud, you're going to get hit with both punitive damages and 3 times the actual damages. And those are different. So let's say actual damages were $5,000. The tenant would get $5,000 plus 3 times that, which is 15, plus punitive damages. And punitive damages are exactly what they sound like. They're designed to punish a landlord. And that's in a situation, like I said, where the court finds that you did it intentionally, you did it maliciously, you did it on purpose, maybe so you could raise the rent or something like that. Again, just like the rent control aspect, the attorney general can bring these lawsuits, a city attorney can bring these lawsuits, the tenant can bring these lawsuits. Now, this law goes into effect April 1st, 2024. So you can expect, just like when we saw a Tenant Protection Act go into effect, it was going into effect, and I saw a tremendous number of cities enact these urgency orders. For example, South Pasadena has already enacted an urgency order, totally prohibiting substantial remodels forever, actually, as a result of this new law that's going into place. So if you're considering doing some sort of a substantial remodel on a specific unit or a building, and you fall under the Tenant Protection Act, my recommendation to you is do it now, get your notices out before these cities start implementing these urgency ordinances, and get this done before, so that your eviction is filed at a minimum before the April 1st, 2024 deadline, so you can get this accomplished before this goes into effect. Now, are there any remedies, or what everybody's going to call it a workaround? I don't call it a workaround. I call them strategies. Any strategies to kind of mitigate these things? There are. First of all, in many units, remember the Tenant Protection Act doesn't go into effect on a tenancy until a tenant's been there 12 months or less. 12 months or more. So a lot of my clients have transitioned to short duration leases. Now, don't transition to an 11-month lease. That's where the courts are going to look at it and go, yeah, you're malicious. You're doing this on purpose to circumvent the law. If you're going to cut your lease durations down, go for like a 6-month lease. This way, if you're going to know if that tenant's a good tenant or not. And if you decide to terminate the tenancy, or you want to do that substantial remodel, you can terminate that tenancy and they're not even protected. If you feel like 6 months is just not long enough, go to a 9-month lease. At least you can say it's 3/4. But if you do the 11-month, it just looks terrible. And I would be strategic and forward thinking when planning the remodel. What do I mean by that? What I mean is sit down with your contractors and talk about, okay, realistically, how long are my permits going to take? How do we build out the bid so I can include that when I serve the notice, so that all of that information is contained in the notice, and it really explains why the tenant has to be out for 30 days, why it can't be done with the tenant safely in place. Work with your contractor to get all that stuff built out into a narrative that you can include with your termination notice. And then finally, work with a good law firm who understands this stuff. Like I said, there's a lot of law firms that are just popping up that are trying their hand at landlord tenant law. They don't fully understand this stuff. They don't fully, they think it's easy. They think it's easy to navigate this stuff. If they haven't been doing this for a long time and done a significant number of landlord tenant cases, then I would consider working with a firm that's done it, understands how to navigate it, and understands what your potential liabilities are. So with that, I think that covers it all. I'm going to turn this back over to you, Jeff. A lot going on in the next couple months. We've got, in January, we've got a new session. A lot of the old laws that we beat last year will be reintroduced, probably under new, well, definitely under new code sections, and with new terms and provisions in them. So we'll be addressing those over the next several months as well.
Great. Yeah, so if you could go ahead and stop sharing your screen. There we are. And there are several questions for sure. Like every single thing that you shared there could be, definitely potential for lots of questions. And so we do have some just to kick off with. With the AB 1620, what was the effective date on that one? It looked like it said January 1st, 2023.
Yeah, like I said, if I didn't, it's effective January 1st, 2024.
24, okay. Yeah, I think it may have said 23 on the
my slide said 24.
Did it? Okay.
I'm looking at it.
Okay, great. And then let's see. What were the lists for AB 1317? There's a list of counties that applied to.
Oh yeah, let me get back to that.
Could you slowly just share that one more time? And we're not gonna shoot you if you miss one.
Yeah, let me jump over to that real quick. 1317, that was way up on the list.
Yeah, I'm going kind of back to the very beginning, and I'll just
sure.
Go
1317 is for Alameda. It looks like it's alphabetic. Alameda, Fresno, Los Angeles, Riverside, Sacramento, San Bernardino, San Joaquin, Santa Clara, Shasta, and Ventura.
Okay, and that's the list that and
that's the list that came right out of the bill.
Okay, so there we go. Okay, and so here's one on AB 12, just with the with only being able to get 1 month's rent. I have seen some people suggest having basically getting out of the appliance business and not including appliances in the lease. So like the stove, the refrigerator. Is that something that's even legal here in California?
To the best of my knowledge, there's no requirement that a landlord provide the appliances.
Okay, so you could potentially say, hey, I have one here in the unit. If you'd like to buy it, you can, or you can bring in your own new one.
That's right. And that goes back to what I was talking about before, where I said, I can see landlords moving into a direction where there's no upgrades, no blinds, no window dressings, nothing. They're just providing a vanilla shell painted white, base white, and anything the tenant wants, the tenant pays for and contracts for. And, so the tenant's going to have to come up with 1 month security deposit plus the money for any of those amenities. So, yeah, I encourage landlords to remove those appliances now.
Okay. Is there anything that needs to be in the lease to say that we are not putting these things in there, or it can still just be your standard lease? And
well, you can use a standard lease, but if you want some language like that, it's very simple to say landlords providing no appliances with the unit. Any appliances that are there are either given to the tenant and are the tenant's responsibility, or shall be provided by the tenant.
Right. And of course, if it's a competitive market, people may just go on to the next one. You may not get your property leased as fast.
Well, that is true initially, but if more and more landlords start doing that,
yeah,
and eventually that's going to go away, and there won't be, all of the competition will be doing the exact same thing.
Right. And I know, like overseas in some places like Germany and other countries, I mean, you just get a shell. You have to rebuild the whole thing, right? All right, here's another one. Shirley, regarding the new security deposit law, can we charge separate for a pet deposit or key deposit, for example, so it's not considered as part of the security deposit?
I love the creative thinking, but the short answer is no. The California courts have addressed this issue many times, and they have said consistently, it doesn't matter what you call that deposit, it's all security deposit. So here's an idea that I'm toying with. And again, I haven't unpacked this fully, so this is not legal advice. It's not encouraging people to do this, but I'm trying to play this out in my head. What if you had a tenant that had shaky credit, and so you're now going to require a cosigner or a guarantor, is what it's technically called, a guarantor, right? But instead of taking more than 2 months security from the applicant, what if you're going to charge the applicant 1 month and the guarantor a performance security of another month? So you're getting 1 month from the applicant, 1 month from the guarantor, but you have to hold them separately so that nobody can claim that that's a security deposit. So that might be, I haven't fully unpacked that. That might be a way around the limitation. But again, this is not legal advice. This is just thought processes I'm having. Okay, so we'll move to guarantors when we have shaky credit, and we'll make the guarantor provide a performance, for lack of a better word, a performance bond on the guarantee.
Interesting. So you'll do more research on that, but you would probably be likely to try that after
I
the
would
effective
be likely to try that. Yes.
So, all right. Okay, let me see what we have here. Let me see. 1607. Okay, 712. For SB 712.
That was the
What
last
about
one.
it? It's, yeah, 712 is the micro mobility devices.
Yeah.
So for that one, what about for everybody that has an existing lease? Do they need an addendum for that they need to get in place?
Well, the short answer is yes. The bigger challenge I'm going to say is, what about these areas, for example, LA, Los Angeles RSO, where the RSO specifically states you can't change the terms of the tenancy and then require or then attempt to evict the tenant when they fail to comply with it. So the short answer is yes. You're going to need an addendum of some sort to make sure that the applicants the tenants understand they have to store it in compliance with those UL codes and that fire marshal code. They have to get insurance. Now, what I will say is, I know your lease, for example, has a provision in it that says they have to comply with all laws. So that might be the strategy, is to notify them, hey, here's the new requirements. It's a state law that you've got to do this. And basically, if they fail to comply, instead of trying to rely on the addendum, you would rely on their failure to comply with the state law.
Right. And it sounds like the fire marshal what's going to happen when that fire marshal comes and he says, this isn't okay. It's the tenant's fault, but are they going to pin that on the owner?
Well, like I said, if the lease has the fire marshal may pin that on the owner, just like every city does, right? Oh, the tenant's creating a problem, I'm going to write the owner a violation. So the fire marshal may try to do that, but like I said, if you've got a lease that's got that provision that you're going to comply with all laws, the mere violation by the fire marshal or the city or whoever writes it would be evidence that they're not complying with the law, and that would be a basis for terminating that tenancy.
All right, and SB 267 question, and that's about you can't require the credit report, just for everybody to remember that, which one we're talking about. So there's different ways that you need to verify them. What do you have ways that you would suggest for them to prove that they're creditworthy?
Well, like I said, the law itself lists those other 3 ways: government benefit payments, bank records, bank statements. So the landlords themselves have to start asking themselves now, okay, what beyond that, what can we do to demonstrate that they're creditworthy? So for example, Jeff, you'll remember this. A couple of years ago, a law passed that said landlords can start reporting the fact that the tenants make their rent payments on time. They can start reporting that to the credit reporting agencies. Okay, so that alone, if the tenant could establish that, look, here's I pay my rent on time every month, and here's my proof of it. And by the way, it's being reported by the landlord. Okay, it's still found in the credit report, but that would be one way to prove that they're credit worthy. Start asking yourself, what else? I haven't really unpacked it yet. I've been busy just kind of figuring out what laws went into effect. But what other documents can I require? How can this tenant demonstrate that they have the ability to pay? Those bank records are perfect, right? I like the bank records because if they provide those bank records, and I've used this myself. I've gone through bank records. My application obviously says there's no smoking, and people who submit it, they check the box. No, I'm not a smoker. I've had people submit their bank records before where they were going to an Indian reservation and buying on their credit card a tremendous amount of cigarettes, right? Mm-hmm. So the bank statements are great. They oftentimes reveal little things that wouldn't otherwise be revealed. Now, if their application says, for example, I pay $1,257 in rent, but their bank statement doesn't show that coming out of their account every month, that's a red flag. On the other hand, if their bank statement does show $1,257 coming out of their bank account every month, either at the end of the month or the beginning of the month, that also is great evidence that they pay the rent. So landlords are creative people, and so are tenants. And over time, landlords are going to develop this list of what will I accept, as long as it's reasonable. And that goes both ways. I'll explain in a minute. As long as it's reasonable, the courts will accept it. What do I mean? If the landlord says, here's my list of documents I'll accept, if that list is reasonable, the courts will accept it. If the landlord says, here's a list of documents I don't accept, or here's a list of things that I will not accept as the reasonable alternative, as long as that list is reasonable, then they can defend that in court as well. Well, why? Because there's no ability to verify that document they gave me is legitimate, right? Yeah. They've got a letter from their brother-in-law that says he lent them $1,000 and they paid it back every month for a year. That's not legitimate. There's a bias there. So as long as these landlords will come, start thinking creatively about lists of what will work and what will not work, I don't think it'll take us long before the whole industry has a list of, hey, here's a bunch of here's a bunch of acceptable ways that a tenant can demonstrate they have that ability and the willingness to pay their rent on time.
Right. Great. Yeah, we're gonna have to put our thinking caps on and work all these things out again. And wow, it's like to have to take 6 months rent. They just went from it being difficult to being impossible for some people. Again, unintended consequences of doing all of this.
Right. Yeah. Or just unintended consequences, short-sightedness, or maybe all that lip service they give about not wanting properties to go into the hands of the corporations. Maybe that's nonsense. I don't know. Yeah. I hate to sound cynical, but
yeah, it seems like they're setting it up to do that.
Right. Every law they pass just has the exact effect that they say they're trying to get rid of.
Right. You kind of wonder if their campaigns are being supported by the industrial. Really, it's like it's institutional. That's the word I was looking for. It's institution grade as opposed to private investment. Like
that's exactly right.
All of us that we know, and I think that mom and pop wording is kind of not working out for us in that sense, because really everybody on city council would agree they don't want the institutional owners to take over everything. I think they would agree to that. I would hope, but they're penalizing people if they have more than 4 units or 16, and 16, that's an arbitrary number, right? Like, who came up with that for having
I have no idea. I think it's based on the requirement to have an on-site manager for 16 units or more.
Right, but like that whole law, who even that number, where did that come from? Like what
I
science
have a
is that based on?
backstory. I can explain that to you sometime, but it
Oh,
was completely arbitrary. And it was
right.
just, that number came out of the air because the story that came to me from a Sacramento lobbyist was because the guy who sponsored that bill owned 15 units.
Yeah. How about that? Right.
Right. So anyway, um, you know, you're exactly right, Jeff, but I'm not so sure that I know this LA City Council does a great job giving lip service to mom and pops. We want to protect the mom and pops, but they just, everything they do doesn't really seem that way.
Right. Yeah. I mean, obviously. So obviously. Okay, here's a question. Ross, under AB 1620, if the tenant already had the disability before they moved in upstairs, can they now request to move downstairs? Or is this only if the disability is recent in the tenant status, like injury, decline in health, etc.?
No, they could have had the disability. It's silent on that issue. The best move is to just say, I don't care when you got the disability. As long as the tenant follows the requirements, then you're going to end up giving them that unit.
Okay. And what if the owner is actually living in that unit? And even in that instance, the owner would have to give up their unit
Oh,
to,
no, no, no. It's only for a unit that goes vacant.
oh, it's when, that's right, that's right.
Right. And if it did go vacant and the owner wanted to move into that, that is a justifiable reason to deny the tenant the ability to use that new unit.
Okay,
The owner's family can move into a vacant unit ahead of a disabled tenant.
got it. Okay, let's see here. 712, can a landlord prohibit a tenant from storing a bike or other micromobility device on a balcony?
Well, it's in the code, if I remember correctly, it did specifically say in the unit, but the balcony is part of their leasehold. They have the right to use that. I wouldn't, let me try to say this accurately. If you've got a provision, and I believe AOA's lease does, if you've got a provision in your lease that already prevents them from storing anything on the balcony, then yes, that provision is still enforceable because they still have the interior of the unit that they could store it and charge it. If you don't have that provision in your lease, I wouldn't start putting that in, oh, you can't store it on the balcony, and start trying to control where they can store it within the unit. And like I said, that balcony is going to be defined as within the unit because it's part of their leasehold. So I wouldn't try parsing words on that. I would rely on a provision that says you can't store anything on the balcony. Forget the mobility devices.
Which is how we're already set up.
Right.
And we've done a lot of changes in the last 30 days. There's been just a ton. And even today, we probably updated 20 forms here. It's December 11th, just to date this video.
Yeah.
And these videos get out of date, folks. If this is the end of 2024 and you're watching this, you need to find the new video.
Right.
Right.
Delete this.
Patrick, maybe I'm not sure if you can answer. 14, this is about AB 1495. Practically, what is this law allowing the Attorney General to intervene without court permission mean to us as landlords?
I don't know what 1495 is.
Yeah, that's just one of the questions here.
I think he meant 1482. Is that what he, oh, I think he's talking, I don't know if this is what he's talking about, but he may be talking about the law that 1418 that I said the city attorneys can no longer intervene and force landlords to evict criminal tenants. So like I said, the cities have always had that. A lot of cities have had that. Basically, they label a tenant that's had some illegal or some interaction with law enforcement or known criminals or known gang members. I've seen plenty of cities go to the landlords and say, hey, we want you to evict this tenant. And if you don't, we're going to prosecute you because your building is a nuisance because of that tenant. And basically 1418 is taking away that ability of a city to shove that down an owner's throat.
And then just wanted to confirm on AB 567, the part about the substantial remodel. So did you say that April 1st was a deadline to put paperwork in to do a substantial renovation to before this thing starts, or
No,
was
it
that
goes,
just,
this law goes into effect on April 1st, 2024.
okay, so
So
not
what I,
July 1st, but April 1st.
correct, July
Okay.
1st is the security deposit. April 1st is SB 567, which changes the Tenant Protection Act. What I said was I would do it now
Yeah,
before any city can do an urgency ordinance, have that notice expire long before April 1st, have an eviction up and running before April 1st. Now, could there be some sort of a law or the court look up and say, yeah, it's true, you got your eviction filed by April 1st, but now we're going to go ahead and make that a requirement, so we're going to dismiss your case. It's possible. Judges can do a lot of things. They have a lot of discretion, but I would still get it going now, get that process underway before these urgency ordinances kick in, before these cities implement urgency ordinances that prohibit you from doing that.
great. Mike, we're so thankful for you and all the time that you put into this. And that slideshow, here's the last question. That slideshow is would you be willing to share that with us?
Of course. Yeah, I'll send it over to you.
Okay, and then we'll put that down at the bottom in the description part, in the more part, we'll put that there so you guys can get a link to that. And everybody can see your phone number and your
Yeah, if you want the phone number,
all of
I'll
your
just,
connection information is there for them to see.
yeah,
And so you can give him a call, definitely. And you service what area specifically, so people
all
know?
of Southern California.
Okay, all of Southern California.
Yeah,
So
everything from, let's call it Kern County south.
great, great. So all of Southern California, even all the way down to San Diego.
Yes, although I must tell you, San Diego's been passing some stuff recently that is making it extremely difficult for me to have any desire to work down there.
Right.
They're
Yeah,
just
their new tenant protection ordinance is a little
brutal.
wonky,
Yeah,
to say the least.
it's just I don't understand, but I don't have to.
Right. Well, hey, we really appreciate you. If you're in Northern California, Richard Beckman is a resource, and you can always open up the AOA magazine and you'll find other sources there for in Northern California. And again, thank you so much, Mike, for this.
You're
And
very welcome.
we'll talk to you later.
Okay, Jeff. Thank you very much.